So I'm going to chat a little bit about a case in California that invoked the Philip Morris case, which some of you are probably familiar with. And it has to do with punitive damages and admissibility of evidence of harm to third parties. It's called harm to third parties, and in the insurance context, I think that's going to mean handling of other claims besides the one at issue in your case. And what happened in the Buell-Wilson case, the court looked at whether a jury can consider evidence of harm to third parties in the design of another vehicle other than the one that was at issue in that case. And they drew this kind of strange distinction, saying that, well, you can't really consider evidence of harm to third parties because it violates due process in assessing punitive damages, but you can consider it for the reprehensibility prong under Campbell, which, who knows whether a jury can actually, well, I'm going to consider it for this thing, but not for that thing. But that's actually right now the state of the law. What happened in the Buell-Wilson case, which was a really terrible case, actually, and you can see why the jury got so angry, actually, with Ford. And what happened, in essence, was it's a Ford Explorer, infamous Ford Explorer rollover case, and the plaintiff was a young soccer mom with several young children and had absolutely no fault in the accident. She had to avert something that had fallen in the road and ended up rolling over and paraplegic, and it was a terrible tragedy. At the trial, she was awarded, as you can see, $300 million in various types of damages. And the trial court reduced those damages on remittitor to something like $150 million, which is still obviously a lot of money. But you can see about a 1-to-1 ratio there on your punitive damages versus your compensatory damages. And the issue on appeal had to do with evidence that was admitted in the trial. And part of the evidence pertained to Ford's decision to manufacture the Explorer, which was a subsequent model of the Bronco. And the Bronco was known to have a high point of gravity. It was too high and not wide enough and would roll over very easily. And there were, internal memos within Ford Motor Company about, the danger and the risk posed, but that it would cost $25 or something to lower the ceiling or reinforce the roof or make it safer, and they didn't want to spend the money. So it was a pretty bad case for Ford, and the idea was that that evidence had to do with a different vehicle, even though it was a predecessor vehicle, that may have caused harm to other third parties who were not parties to that case. And the court looked at the Philip Morris case in deciding that the evidence could be considered. And the court goes into this distinction between allowing the jury to consider that evidence for purposes of assessing the amount of punitive damages versus allowing a jury to consider it in determining reprehensibility. And the reason they allowed it for the reprehensibility in this case is that, of course, it put Ford Motor Company on notice of the danger of that particular design. And they adopted a similar design when they developed the Explorer, and the fact that they knew that it had that risk, they knew it could be remedied for a very small amount of money, and they didn't do it, does go to reprehensibility. I mean, it makes sense. So the court allowed that evidence. The Philip Morris case is up for review in the U.S. Supreme Court, and so both these cases are actually on hold pending that ultimate review. But if they are upheld, it could have, these decisions could have some impact in the insurance context by allowing admissibility, not only discovery, but admissibility of evidence of harm to third parties in the form of either other claims, other verdicts, other punitive damage verdicts, other cases involving that adjuster. You know, there's all kinds of different ways it can be framed. Now, it's a little bit different in the insurance context from the product liability, unreasonably dangerous activity type of case or tort case, because claims handling, you know, in the different states could be regulated differently. There could be case law in various states interpreting exclusions that may not be applicable in other states, and I think Campbell somewhat addresses that and would probably be limited to other acts within the state where the loss took place. But other than that, you know, the only guidepost is going to be that the other claims or other lawsuits or other evidence involve similar circumstances to the one at issue. And similar is, you know, one of those things that I think is going to be debatable, and reasonable minds are going to differ as to what constitutes a similar case. Some states, like California, have case law that actually already allows discovery of other claim files. We have Colonial Life. We've had that on the books for, I don't know, 15 or 20 years. And, you know, it allows discovery of other claim files which are similar. And there's always a big argument, a big motion before a discovery magistrate or discovery judge to decide what is similar. And, you know, the request is usually something like all other mold claims ever. And then you fight about whether, you know, that's overly broad. It should be 2 years. It should be homes. It should be businesses. It should be involving this adjuster. It should be only claims that were denied, or, you know, however you want to frame it. But there's usually a battle over narrowing that down. But at the end of the day, once you can come up with a reasonable subset of the request, it's allowed in California. And if Buell-Wilson stays on the books, it will then arguably become admissible in evidence to show reprehensibility if there's a punitive damage phase. So you could have kind of a pattern and practice type evidence coming in to show reprehensibility if you hit a punitive damages phase. One caveat in the Buell-Wilson case is that case is actually, as Jay pointed out this morning, a legal malpractice case, because what happened in that case was counsel never, well, they waived their Philip Morris argument, and it had to do with the way that the jury instructions were framed. And the Buell-Wilson court sort of gratuitously explained exactly how they would rule if it hadn't been waived. And then they come out and say, well, it's been waived. So it's kind of a funny decision that way. But it's a lengthy one. I mean, it's like 70 pages. And they go into great detail about how they would handle it if it hadn't been waived.